Call the second case for the morning, Haywood Dean et al. Versus Akal Security. Please proceed.
Good morning, everyone. Ms. Rassif. May it please the court, my name is Matt Sarelson. I'm here on behalf of the 102 appellants in this case. I've spent several weeks trying to come up with a really interesting one-line opening statement. I'm normally pretty good about that, actually. And I keep coming back to one sentence, which is all I really need to do is be candid with the court. I might lose this case at trial. There are facts that are not helpful to my clients on compensability. But we may also win at trial. There are extensive facts in the record that show why these alleged meal breaks are in fact not bona fide meal breaks within the meaning of the act.
Counsel, let me ask you as a threshold question, are we all on the same page with regard to the burden of proof in the case and before we get into the facts?
Well, I believe we are. The current state of the law in the Fifth Circuit, and it's come up many times, it's not like it's one case from the 70s, it's come up multiple times, is that it is the employer's burden of proof. That's our position, and I think the brief by our friends on the other side made it clear that they want the court to reverse that at some point. I respectfully don't believe the court can do that today, but they want to reverse that. And there is, I acknowledge that there is a split among the courts about the burden of proof. I think it's roughly 50-50. It may not be exactly 50-50, but some courts say plaintiff has to testify that they work, and then the defendant can rebut it.
What is it in the 11th Circuit? Isn't there a case similar to this?
It is. The Gelber case is the 11th Circuit case.
Right, and what is there?
So in the 11th Circuit, the plaintiff bears the burden of proof. What's interesting, and it's an interesting, you can sort of see how burdens of proof have a potential impact. So in the case in Miami, we had cross motions for summary judgment pending in front of the court. The parties agreed there were no facts in dispute. We just each wanted the court to rule as a matter of law. Why is that? Because in the 11th Circuit reads the regulation 785-19, reads it literally. If they're not completely relieved of duty for the purpose of eating a regular meal, judgment for the plaintiff. And after the first day of trial, it was a little bit weird. Summary cross motions were denied. And then at the first day of trial, Judge Moreno, very distinguished judge in Miami, said, there's nothing to try. You all are in agreement. This is just for me to decide. And he said, this is a case with weird facts. And there is no appellate decision on point anywhere in the country with precisely similar facts. This happens to be a unique case. It's a unique industry, and it's a unique company within the industry because they're the only one doing it. So in that case, Judge Moreno ruled as a matter of law that this was compensable because they were not completely relieved of duty for eating for purposes of a regular meal. Akal appealed.
You saying the facts of that case are materially different than the ones in this case? As I understood from the briefing, that the employees are all similarly situated, their tasks are the same, their experience on a daily basis is the same?
Correct, Your Honor. So we moved for nationwide certification, and it was objected to by Akal. We got statewide certification, and we just had to file parallel lawsuits because of the certification issue. So as a practical matter, there's really no difference. Either you fly into Alexandria, you fly into El Paso, you fly into Miami, but in a material sense, there's really no difference.
Has the case been argued in the 11th?
It was argued, I'm sure Ms. Rassif knows the exact date, but it was argued in early January. where we were the appellee. The situation was a little bit reversed in that case. And certainly, from my position at least, our confidence remains high that we'll be able to keep that judgment. There's also something that's a little bit different. The 11th Circuit doesn't adopt the predominant benefit test. There's a lot of courts that don't do the predominant benefit test. The 5th does, the 7th does, the 11th doesn't, the 9th doesn't, some other courts don't. The DC Circuit does. And why does that matter? Because in this case, we did not move for summary judgment for the employees. Why? Because it would be a little bit like unfair and disingenuous for me to say that the test in the 5th Circuit is a highly fact-intensive case where the defendant has to prevail beyond peradventure, which is a really high legalese standard, beyond peradventure, right? So I can't say to the district judge, hey, there are no facts in dispute, etc., vote for us. Oh, but at the same time, the test is an extremely fact-intensive test. The bottom line is the 5th Circuit looks at the totality of the circumstances, and then the jury gets to decide. And the way I think about it is, there are a lot of facts that, frankly, I wish my clients weren't allowed to read a magazine. But they can read a magazine. It's a fact I can't dispute. I also wish my clients could make a phone call to check on their kids during this meal break, because that's what most people would do on a meal break. They can't do that either. So the plethora of facts about what they can and cannot do, the freedoms versus the restrictions, you line all of that up on a piece of paper and you bullet point it. There are facts that a jury could go in our favor. There's also facts that a jury could go in Akal's favor, and we're prepared to try the case, and if we lose the case, that's fine. And this court in particular, there have been 3 published meal break cases and 1 unpublished meal break case out of the 5th. In every one of the published cases, the case went to trial. It may have been a bench trial, it may have been a jury trial, but it went to trial. 2 out of the 3 times the employee won, 1 out of the 3 times the employer won. The adverse party, surprisingly, appealed to this court. And this court affirmed in all those cases saying, no, this is a jury question. The jury heard all the evidence, or the judge heard all the evidence, credited the witness testimony, the normal things fact finders do. We're not touching this verdict. This is a quintessential jury question. The one case where the employer won summary judgment on a meal break case was the Naylor decision out of this court from a couple years ago. I believe Judge Costa wrote the opinion in that case, and that reversed summary judgment and said, no. You can't rule on a meal break as a matter of law. This is the sort of thing that a jury has to decide because, there may be some compelling facts as to why the employer might win, but that's not the standard. There's just as many compelling facts. It also came up recently in the Dewan case. I'm not sure I'm saying that right, authored by Judge Southwick. I think it's pronounced Dewan, could be Devon, I'm not really sure. It was not a meal break case. It was an exemption case. It was a statutory exemption case. And the question was, has the employer proved beyond peradventure that these were exempt employees? And it was no. The order's reversed. There's some really compelling facts. And the case went through all the facts and said, these are all the facts that would support a verdict for the employer. But you still have to convince a jury or a judge in a bench trial of this because it could go either way. And in fact, I believe it's the final sentence of the Dewan case that says, this may be a case that we're remanding just for the defense to end up winning a trial as opposed to summary judgment, but so be it. The only case in the 5th Circuit where a summary judgment for an employer was affirmed was this court's decision in Alvarez versus City of El Paso. That was an unreported case. Putting aside whether it's precedential or not, let's talk about the facts about the Alvarez case. There were 2 things at issue. The employees who worked for the City of El Paso could do absolutely anything they wanted on their so-called meal break, except they had to wear their shirt that said City of El Paso. And when they went to lunch, they had to take a city car as opposed to a privately owned car. They could go to lunch, they could run all the errands that you would run, go to a doctor, pharmacy, bank, call to school to check on your kids. They just had to do it wearing a City of El Paso shirt. And what this court said, which I agree with completely, is those aren't restrictions at all. Those are inconveniences. You may not like the fact that you have to go to McDonald's in a City of El Paso shirt, but you get to go to McDonald's. You get to go to the bank. You get to do the other things. And I'll be candid, I've read Alvarez. Alvarez, by the way, is the case cited primarily by Akal in this case. It's the case where they say, look, you can grant summary judgment. Here's a case. But it's a really bad case for that. And I'll be honest, I do a fair amount of FLSA work. If Alvarez and his colleagues came to me with those facts, thank you, no, I would turn that down in a heartbeat. There was absolutely no merit to that case, and I have no qualms with summary judgment for the City of El Paso in that case. The facts in our case are so much worse, so much more restrictive, that it's tough to even come up with a comparable case, not just in the Fifth Circuit, but anywhere. I mean, we've scoured everywhere because this is pending in multiple jurisdictions. I've never even seen a case come close to saying you can't make a phone call, you can't get fresh air, you can't check the internet, you can't watch TV, you can't move. All of these other cases are situations where, because this comes up a lot in security guard type cases for some reason, you get to leave where you actually work, and you get to go to an employee break room. There's a pretty good case out of the Sixth Circuit. It's this casino case. It's Rufin versus Motor City Casino. I just call it the casino case. The casino case is the closest case to support a call's position. It is not close, but it is the closest case. And in that case, the security guards could leave where they worked, but they were not allowed to leave the premises of a casino, which is not an airplane. The casino is a much bigger property. They could walk around, they could take a smoke break if they wanted to, they could make phone calls, check on their kids, and do all the other things. The only thing they couldn't do was physically leave the premises of a casino, which is a large piece of property. They could go to the restaurants, they could do everything else. That is candidly the closest case, and I don't think that case is actually close from a fact perspective. As I understand Akal's central argument is, and I believe this is what the district court picked up on, was we acknowledge that there's all these restrictions, right? It's not subject to dispute that they can't make a phone call, that no one's disputing that fact, just like no one's disputing that they could read a magazine, right? Most of these facts are not in dispute. But what Akal's argument is, as I perceive it is, that's just because we're on a plane. That's not our problem. So don't fault us. We're giving you a break, but it's subject to certain limitations. Or as they say repeatedly in the briefs, and as the other cases say, the test is, are these employees free to do as they wish? And the answer, from my perspective, is no. It's not close that they're not free to do as they wish. Let's try the case. Akal's perspective, as I interpret it, is they're free to do whatever they wish, subject to the fact that they're on an airplane at 35,000 feet. And that phrase, subject to the fact that they're on an airplane at 35,000 feet, that's doing a lot of work in that argument. That's an enormous restriction. That's like me saying, I'm free to do whatever I want right here as I stand at that podium. Well, that's true, but I can think of lots of things that I can't actually do sitting here. So I'm free to do whatever I want as long as I maintain the courtroom decorum and act as an officer of the court and not walk around, hollering or something like that. So sure, there are certain restrictions, and those are restrictions that are part of the job. But if it is the nature of the job that imposes these restrictions, that's the reason you have to compensate them. It's not an excuse for not compensating them. I have about a minute of my time left, and I'd like to add that to my rebuttal if that's possible. Not possible, okay.
Let me confirm with
Sure.
you. The claim, what you're seeking is compensation for the meal time on flights where there are no non-employees on board.
Right.
Is that correct? So it's only the security guards and, of course, the people flying the plane
Yeah, there's a flight crew. Department of Homeland Security has an officer on board. There's a flight medic on board. It's actually a big production, to be honest. But only my clients are contracted out through Akal. So there's 13 of them, plus various government employees, plus various airline employees. Okay. I'll come back on rebuttal. Thank you.
Good morning. May it please the court. My name is Jenna Rassif. I represent the appellee, Akal Security. Good morning, Mr. Sarelson. I haven't attempted to come up with a great one-liner because I don't think I probably ever have. One thing I will say right out of the box here is it's not that there are a lot of undisputed facts in this case. It is that they are all undisputed facts in this case. This case is, as the appellants say in their brief, exactly the same as the Gelber case in the 11th Circuit. It is exactly the same as the Alonzo case in the 9th Circuit. These cases all involve the exact same set of facts, and the facts are undisputed. The 9th Circuit ruled in favor of Akal Security on summary judgment using a more challenging standard than is used by the 5th Circuit. It's using a completely relief from duty standard. The 11th Circuit ruled against Akal using that same standard. And we stand before this court after Judge Drell in the district court ruled correctly in favor of Akal Security. The key to this case is that the aviation security officers who are on this plane have all testified that they have at least 1 full hour of no duties, completely free to do whatever they want to do on that airplane on every empty return leg. They've all testified to that. Now, what that means is that, yes, they can do whatever they want on the plane. However, what has been problematic with the employee's position throughout this litigation and in every court, including in the very esteemed Judge Marino's opinion in the district court in Miami, is that they have ignored very explicit regulation from the Department of Labor and 2 very explicit regulations and very clear case law across all of the courts. That number 1, there can be a meal period on a plane. Department of Labor Regulation 29 CFR Section 785.41 explicitly provides that for employees who fly a plane or are assistants or helpers on the plane, they are to be paid for the time that they are traveling on that plane, except during a bona fide meal period. That piece right there tells us that the Department of Labor accounted for the fact that there are going to be natural limitations imposed by being on a plane, but that those limitations do not preclude the viability of a meal period on that plane. Section 785.19b provides that an employee can be required to stay on premises and still have a bona fide meal period. The case law out of this circuit and every circuit has numerous instances of employees who are heavily restrained on premises but still provided bona fide meal periods. For example, in a Department of Labor opinion letter, there are employees who work receiving fare revenue in New York. Those employees were required to stay in a very small break room to protect the security of that fare revenue, couldn't smoke, couldn't watch TV, couldn't make phone calls, and the Department of Labor said, it's okay, as long as they are still otherwise able to do what they want in their personal interest. The case law is replete with employees with heavy restraints because the key consideration is not that there is just a limitation on your freedom. It's not, I can't call my kids, I can't go to the doctor, I can't go to the dry cleaner. That's one part of the analysis. The second part of the analysis, which is repeatedly overlooked in the employee's analysis and respectfully in Judge Moreno's analysis, is that those limitations that are imposed must inure to the benefit of the employer. Whether or not the employee can call their children is not a limitation on their freedom that is inuring to the benefit of a call. So when you review the case law that's in analyzing these limitations, what you see is that if the employer has imposed the restriction, then we have to look at, okay, now is that restriction's inuring to that employer's benefit? That's going to be a factor that's going to weigh against the employer in the analysis. But what the employees are complaining about here are limitations on their freedoms imposed by the fact of being on a plane. There is not one limitation about which they are complaining that is inuring to a call's benefit. And so this court's four-factor test on the predominant benefit goes through, firstly, are there limitations on the employee's freedom that inure to the employer's benefit? Are there restrictions imposed by the employer? Does the employee have substantial duties that they have to perform during the meal period? And are there, I don't know why I've forgotten that fourth prong, forgive me. How frequently is their meal period interrupted? Every employee has testified they have at least 1 full hour on these empty return legs when they have complete opportunity to pursue purely personal pursuits, and they have absolutely no duties. They are not interrupted, and they have no restrictions imposed upon them other than having to wear a uniform and follow the policies of the employer, which, as Mr. Sarelson pointed out, have been deemed minor inconveniences, quote unquote, by the Naylor Court. Each of the four factors that have been applied here, the employees across the board in this case have testified they don't have any imposition on them. The remainder of the empty return leg is paid time. And their testimony shows that they, in fact, often have free time into their paid time. But that's not really pertinent here. What's pertinent and most important here is that they always have, always, at least 1 hour on that empty return leg when they have nothing to do. Purely personal interest, pure pursuit. I'm happy to address any other questions or concerns you all might have.
Thank you, Counsel.
Thank you.
Are you a tag team, as it were? Did you both argue the 11th Circuit case?
Forgive me, Your Honor?
Did the two of you argue the 11th Circuit?
I argued in the 11th Circuit, Your Honor, but I do not remember the exact date. That was quite complimentary to think I would have remembered that.
January 15th, I think, but I don't remember it. I just saw it in my notes.
May it please the court, my colleague Dan Sampson argued in front of the 11th Circuit. He was not able to argue and prepare this case. I think the way Akal presents the case is sort of telling and somewhat correct. There is an acknowledgement that there are these restrictions on them. And the question becomes, and what the district court essentially ruled was, these are restrictions that are a function of the job itself, not something that we should hold Akal to be responsible for. And that doesn't find any support in the text of the Fair Labor Standards Act. It doesn't find any support in any of the implementing regulations, including the one that's at issue in this case.
Well, what about the regulation that your friend on the other side quoted, that at least Department of Labor recognizes that you can have a meal period on an airplane? So the recognition of the restrictions that arise from an airplane is part of a regulation.
So let me address that. That is Section 785.41. That's not what the regulation says. What the regulation says is any work which an employee is required to perform while traveling must, of course, be counted as hours worked. It then goes on to say, an employee who drives a truck, bus, automobile, or an employee who is required to ride therein as an assistant or helper is working while riding, except during bona fide meal periods or when he is permitted to sleep in adequate facilities furnished by the employer. That regulation, which has never gone up to any court, as far as I know, and I do not know where that regulation comes from. Normally, the regulation adopts an appellate decision. That regulation applies to people who work for the airline or the trucking company. So the way that works is, if you drive a truck for UPS, you're the driver, and you might be able to have an assistant or helper who helps with the loading. Those people, even though part of their job is to travel, they can stop, they can go to Dairy Queen. The UPS officers by my house will all stop at this one particular Dairy Queen every day at 3 o'clock, and they have a meal break. It's talking about that these are not employees who drive a truck, bus, or automobile. So the only way this would work is if the phrase ride therein as an assistant or helper, but it's an assistant or helper to the person who is driving the vehicle or piloting the plane in this case. It's essentially the co-pilot or the co-driver. This regulation doesn't apply on its face to simply people who happen to work on an airplane. It's actually never said that. It's never been applied that way. Moreover, there's a really important comma. It says, comma, except during bona fide meal breaks. And so all this regulation is saying is, if you happen to be someone who travels for a living, you can still have a bona fide meal break. It's not saying you can have a bona fide meal break in the air, or you can have a bona fide meal break while driving down Interstate 10. That's what Akal wants this regulation to say. That's not what the regulation says. It applies in a totally different context. It applies to the people who are driving the vehicles and the assistants to the drivers of the vehicle. Our clients don't work for the airline in any way. They work for a private contractor. So this regulation doesn't apply at all. But more importantly, even if the regulation were to hypothetically apply, you still have, Akal is still presented with the burden of proof to show that there was still a bona fide meal period. And so even if hypothetically, you can imagine an airline having bona fide meal periods, hypothetically, on a plane. You could imagine when these planes stop in, let's say, Guatemala City, when they're done dropping off deportees for the day, the plane can spend an hour on the ground refueling, and during that time, the employees can go to the airport, and they go to the terminal, they can get on the phone, they can do the other kinds of things that you would do, and that would be a much more favorable fact pattern for Akal. In this case, and it goes to what Judge Engelhardt was asking, there's no actual meal break. They've all universally testified that there's no meal break. There's a meal break policy in place. And what they do is they take the position that if the flight's long enough, we're gonna take 1 hour away on the theory that there's a meal break. Now, there's no actual record evidence of a meal break. In fact, the record evidence is to the contrary. But what we're really talking about, Akal's position is the meal break policy is lawful. Our position is the meal break policy is a written policy. What matters is the facts on the ground, or in this case, in the air. My time is up. I'm grateful to be here, and I urge reversal. Thank you.
Thank you both for your assistance on this case. We'll take it under advisement. Closing on that very hopeful note, this is the final case of this panel in this courtroom this week. We are adjourned.